we are sitting after 1 hour behind. So for today, all mentions are allowed except unlisted and mentions to bring on record affidavits or missed cases. All other mentions for adjournments are allowed subject to there being no objection from the other counsel. Okay? Dates, you'll get it from the court master. I said all mentions allowed. Yes. Item 15 at the request of the counsel, on the submissions of the counsel for the petitioner, Mr. U.J. Soikia, that why do you want to withdraw it? Because of some factual corrections are required to be incorporated. He seeks liberty to refile the same after incorporating the corrections. Prayer made is allowed. WPC so-and-so stands dismissed on withdrawal with liberty. Interim, is there any interim here? No. All right. I told you, yes. Item 3 on the submission made by MSS Bora. Matter stands dismissed on withdrawal. Interim orders, if any, stands vacated. Pending ayes are also dismissed. Yes. 44. All right. When do you want it? Tuesday, we are already tied up. 26th August. 26th August. Item 44. Yes. Item 1. Yes. Where is the order? Twenty-three, 24. All right. Heard learned counsel for the parties issue notice. Returnable 4 weeks. Steps on respondents by registered post AD as well as usual course. Matter to be listed after returnable date. Huh? For withdrawal, item 61. No, then why do you want to withdraw? Then you don't need liberty. It will be a fresh cause of action. On the submissions made by learned counsel for the petitioner, Mr. M. Hussain, the writ petition stands dismissed as on withdrawal. Interim orders, if any, stands vacated. Liberty granted. Item 2. Page number. Heard. Counsel for parties issue notice. Returnable 4 weeks. Steps on respondent, sole respondent by registered post ID as well as usual course. Matter be listed after returnable date. Item 4. Yes, Mr. Dotto, you're appearing. What instructions? Mr. M. Dotto for the petitioner, Mr. A. Fukon for Standing Counsel GAD, MS M. Bhattacharya for respondent number 3 and 4, Mr. S. Dotto for respondent number 2. Mr. Fukon on instruction submits that the representation filed by the petitioner. Now, what is that? Appeal. Appeal petition filed by the petitioner is fixed for hearing on 1st of August 2025. In that view of the matter, this court considers it appropriate to defer the matter for 2 weeks. List this matter again after 2 weeks on 20 August.
Second 5. They have Rule 26 right there. The process of it. Rule 26 being contemplated. So identify as having a medical condition. You are then given 30 days time to face. 30 days from a civil job. When you file an appeal, then the review board is constituted. Thereafter, the report finds that you are unfit, that you are innocent. My case sort of happened. I see. Because you, when he went to the team alone, when you are immediately identified, you are sent to one teams in bulk. That opinion has come into favor. Secondly, you are again sent to have medical. That opinion also has. These are opinions from my civil judgment. Based on that, but no reviewer. He continues to do surveys. In 2025, he is again sent to a CRPF officer. Based on CRPF's opinion, now the discharge of the saying that you have been from the recruitment of the not of the basis of civil service, but of paramilitary purposes.
You need to respond to the contentions. No, but the procedure has to be followed as per the rules. You need to bring it on record what procedure you follow. You need to bring it on record so that they get an opportunity to contest this if required. According to you, the procedure has been followed, but there is nothing on record to show that. You've not filed your affidavits. So file it, bring it on record. We will examine it. Whatever it may be. We have stayed the order, I think. So bring it as early as possible. 2 weeks. Bring it within 2 weeks. Then we'll examine and see. So you want us to issue notice? Or you can bring it on without notice? Without notice. All right. Mr. B. Pathak for the petitioner, Mr. B. Pegu, learned CGC, submits that instructions have been received, that the procedure required under the Assam Rifles rules 2010 has been followed, and therefore there is no infirmity in the order which is impugned in the present writ petition. Stop. The petitioner, counsel for petitioner on the other end, reiterates his submissions that the procedure has not been followed. He came to be aware of the order of invalidation or discharge. Invalidation. Huh? Invalidation leading to discharge only upon the copy of the same being served on him. As per the requirement under the rules, he was not informed nor given an opportunity to obtain an opinion from a civil surgeon. Stop. In that view of the matter, the learned CGC submits that he would like to bring on record these instructions by way of an affidavit. He prays for 2 weeks. Prayer made is allowed. List after 2 weeks. List on 18th. 18th. Interim order passed earlier will continue till 18th. 20. Interim order passed early will continue till the next date fixed, 20. You serve extra copies.
I can see.
What is the net instructions? Factual details are not available.
It says that where one spouse belongs to one state service and the other spouse belongs to another state service. The spouse with the longer service that the state may apply to the appropriate cadre controlling authority and the place may post the state officer to the extension of the other. So why not that details is not available. So
I think your wife may have filed some application, isn't it? What happened to that? But that is in the education department. Which, oh, health department. But she's an employee of education. Oh. Hmm. So who has longer service? Hmm? Longer, so he has not filed an application. What is wrong with the husband filing directly? You consider it and pass orders.
Because that online portal was for the purpose of mutual transfer. When
You want to file an application, physical application, you file it, and we'll direct them to dispose it of. How much time do you require? Then you withdraw this petition, file it. If you're still aggrieved, you can come back. You, you have not filed an application. Then we'll have to close it. All right, heard. Counsel for the parties. This writ petition has been filed by the petitioner, who's you're serving where? Is serving in the which post are you employed now? Is working, is serving as a multi-purpose worker and was posted in Pukhuripar Sub-Center, Boko Block, PHC, Kamrup. Stop. By order, where are you posted now? Oh, sorry. He is posted at Simona Bosti, BPH, Nogam. And you are, which is the impugned order? 1/2/25. By order dated 1st of February 2025, the Joint Director of Health Services, Nolbari, released all the persons in the said order who were attached from different health institutions in the state and working in the Nolbari district. Stop. Name of the petitioner appears at serial number 71. He was released from Botahgali SC under Komarkusi BPH, and he was required to go and join at Soriabari SC under Simona Bosti BPH 31, page 31. It is original place of posting. Stop. It is submitted that his wife is employed under the education department and is also posted in Nolbari. And his spouse had preferred a representation before the appropriate authority on behalf of the husband. Stop. Learned counsel for the petitioner refers to the OM dated 21st of March 1987. To submit that where one spouse belongs to the public sector undertaking either and another working at the state government service, either of the two may apply to the appropriate cadre controlling authority. And no, sorry, you are referring to two, sorry, where one spouse belongs to one state service and the other spouse belongs to another state service. The spouse with the longer service in the station may apply to the appropriate cadre controlling authority, and that said authority may post the said officer to the station of the other spouse. And if there is no post in the said station, then to the nearest station where a post may be available. Stop. Para. The State Council, upon being permitted to complete his instructions, submits on instructions that the health department is, in order to apply these clause 2 of the said OM dated so and so, the health department is yet to receive full details of the station-wise length of services of both the petitioner and his spouse. And since these facts are not available before the health department, no specific orders can be passed under the said OM. Stop. It is the submission of the State Council that the petitioner also did not file any representation with reference to the said OM dated so and so. Stop. Para. In view of the submissions made by the State Council, the learned counsel for the petitioner craves leave of this court to file a detailed representation before which authority? Joint Secretary. Before the Commissioner and Secretary, Health and Family Welfare, Government of Assam. And pray for modification of the order in view in terms of the OM dated 21st May 1987. And the case of the petitioner thereafter may be considered by the respondent authority in terms of the said OM para. In view of the submissions made by the counsel for the petitioner and not objected to by the counsel for the respondents, the writ petition stands closed with a direction to the, with a liberty to the petitioner to file a detailed representation giving factual particulars with regard to the length of service of the petitioner as well as his spouse, so that the authorities may take note of these facts and pass appropriate orders in terms of the guidelines issued under the OM dated 21st of May 1987. If the petitioner files such a representation within 2 weeks from today, the respondent authority will consider his case within a further period of 4 weeks from today. From the date the such representation is filed. Under such circumstances, the release order, insofar as the writ petitioner is concerned, will remain stayed till such representation is filed and disposed of as directed, or till 3rd of September, whichever is earlier. Where? You have already joined. Then interim order null. Yes.
Item 7.
Yes, boss. Yes. Page number? Yes. Hmm.
Is also a senior assistant in the engineer. He was transferred to chief engineer in place of traditional.
How does it affect you?
Engineer office, director there. And then whereby the respondent for the respondent is from the executive engineer, the three level. So the tools that this process are governed by different rules. Thereby, the promotion is the respondent has been transferred to the place where the petitioner was posted. So these exemptions apply in the next promotion list. The petitioner right promotion the both of assessment division. In the petition list.
We'll issue notice at this stage. Beyond that, what interim? No, why? What is your difficulty? All right, we'll issue notice on interim. Heard, Learned Council for Parties. Issue notice, returnable 4 weeks. MSR Deca appears on behalf of respondent 1, 2, and 3. Since MS Deca appears, notices are waived, extra copies will be furnished within a period of 1 week from today. Steps on respondent number 4 by registered post AD as well as usual course. Issue notice on the interim prayer. Returnable on 29th. Make it 3 weeks. 3 weeks could even. Notice 3 weeks. Returnable on 27th. Hmm. You are saying that chief engineer's office is governed by district ministerial service rules. Ah. Executive engineer is by? Chief engineer's office. Yes. He must have gone and joined. Ah. If you have joined, then why is the interim? Huh? We'll look into it. But there is no interim order as such. Interim to Rahida, we'll see what happens. Returnable, yes. Hmm. We'll issue notice at this stage. All right. Third, Council for Parties issue notice, returnable 4 weeks. The MS P Thapa appears for respondent number 245. All right. And Mr. C.K.S. Borua for respondent number 1, M.S. H. Borua for respondent number 3. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. The claim of the petitioner, the grievance of the petitioner is not non-release of his arrear pay by the respondent authorities. Stop. Pendency of the writ petition shall not be a bar for release of the amount which is not disputed by the department. Returnable. All right, list this matter on 3rd of September.
Item 9.
Hmm? 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 What? Show us. Minimum scale. Yes, Mr. Bora. All right, heard counsel for parties disposed. Mr. S. Bora for 5 to 10, Ms. H. Bora for? Huh? Respondent? 4. Anyone else? Disposed.
Item 10.
Hmm? Hmm? All right. Heard landed counsel for petitioners issue notice. Returnable 4 weeks. Mr. Ardhor appears on behalf of, accepts notice, appears and accepts notice on behalf of 1. Who's for 2, 2, 3, and 4? All right. 2, 3, and 4 steps be undertaken by registered post AD as well as usual course within 1 week from today. Matter be listed after the returnable date. Extra copies be furnished to the counsel representing respondent 1.
Item 11.
Hmm. What is your grievance? Notice. False. You withdraw or we direct them to lodge an FIR against you for submitting false certificates. You admit that you have submitted false certificate. You admit. You admit that it is false. Now you submit genuine. Then you withdraw or we dismiss it with cost. What is the right? You submit a false certificate knowing it to be false. Then you admitted that it is false. Where is your reply? He was appointed. What is the procedure for selection and appointment of cooks? Some advertisement is there. Why is why is the certificate declared to be false? Means it is non-existent. Then you have submitted it. Applied online where?
From the authority, my lord. I contacted
Which authority?
the authority, my lord. Where is the name, my lord? It is called, my lord, the National Skills Qualification Framework, NSQF, Level 1 course in food production or kitchen from National Skill Development Corporation or from the institution recognized by National Skill Development Corporation. Page 28, it is.
No, your page number 44.
Yes, ma'am.
Your reply. You said you submitted some certificate which was declared as false.
No.
This certificate you have applied for certificate, you have received that certificate.
Yes.
So you know it was false.
I could not able to ascertain whether it is false or after scrutiny only.
What do you mean you could not ascertain whether it is false?
I annexed this certificate, sir. Is 41. It is seemed to be genuine.
No. How did you apply for this certificate? How did you get this certificate?
By applying online application.
Online?
Yeah.
How can they give you an online certificate?
And this course is also.
Where are the markings in your course? What assessment have you got for the course?
I have stated in paragraph, my lord.
Who prepared this false certificate?
My lord, this they as per, my lord, this report, my lord, and there is no existence of that authority, my lord.
So who gave you this certificate?
My lord, it is my lord, page 41. It is named as RASI.
CI, Retailer Association Skill Council of India, and seal also there, my lord, Director Assistant. Lordship may kindly see.
Where is this institute?
This institute is, my lord.
Where is it
based in
located?
the Government of India, Ministry of Skill Development and Entrepreneurship.
Where is it located?
My lord, is
Lordship may come to page 43 for a moment. Uh, it starts from 42, the paragraph. And 43, the Director, National Skill India Mission, Diamond so-and-so, Kerala, to ascertain the veracity of the said certificate, write this unit so-and-so. In turn, National Skill India Mission, Skill Bhavan, so-and-so, Kerala, by the letter number so-and-so has intimated, the attached certificate is fraud and not issued from this office, and the signature affixed on it are not that of any of the officers of this office. The model of the certificate issued from this office is also different. Please collect information from the certificate holder from which agency they have got this certificate and please inform. So it has not been issued by them.
Where is this communication? Is it here somewhere?
It is not, he has not annexed it.
All right, we're dismissing it.
my lord,
Wait.
may allow some time, man.
Huh?
I may allow some time, man.
What sometime? You know that a certificate is false.
My lord, I stated that I don't know, my lord.
No,
So
no,
I
how,
did not
how, that is what we are asking you.
reply also, my lord. My
No, no,
reply.
how, why will anybody give you a false certificate? Either the institute is bogus, it has not been recognized. This is not the case. This is not what is being stated by the authorities. Authorities say
No.
the institute on its own turn says that this certificate is not issued by them. Then
And instantly he gives a new certificate.
counsel for the parties. The writ petition is filed by the petitioner,
My lord,
praying for setting aside of the order of dismissal of the writ petitioner. By order dated 8/2/2025, issued by respondent number 4. The petitioner was applied for and was applied for the post of constable tradesman and was appointed as a BSF constable within bracket cook by the appointment order dated 9th of April 2024. Stop. This appointment order was made provisional and subject to verification of documents. Stop. Petitioner was posted in 65 Battalion BSF, Painthi, District Samba in the Union Territory of Jammu and Kashmir, as it then was. Stop.
my lord.
It,
I will be allowed to also, my lord. With my
the
request,
petitioner
pending.
Was thereafter discharged by the impugned order upon internal verifications being made by the respondent authority. The verification returned a finding that the certificate in support of his skill as a tradesman within bracket cook, which was submitted by the petitioner, was declared to be false by the institute purportedly from which the petitioner obtained the said certificate. This is clearly reflected in the
Show cause notice, page 42, relevant portion at 43.
and the show cause notice which was issued to the petitioner at page as annexure in the is it annexure 4?
Annexure 4, Lordship.
Annexure 4. show cause notice dated 2nd of November 2024. Stop. In his reply, the petitioner stated that his certificate has been declared to be false. Subsequently, the petitioner submitted a certificate which, according to the petitioner, is genuine. And therefore, the petitioner approaches this court for setting aside the dismissal order and for acceptance of the subsequent certificate which the petitioner claims is to be genuine. Stop. Vera. After arguing for, after due submission at some length, petitioner submits that he would like to withdraw the writ petition. Stop. In view of the submissions made and the pleadings available, this court considered imposition of cost for wastage of precious judicial time. However, in view of the submission that the petitioner wishes to withdraw the writ petition, such orders are not passed by the court. Writ petition is dismissed on withdrawal. Mr. R.K. Dev Chaudhary appears for the
Response.
respondents.
All right. Item 12.
Notice. Notice at this stage?
No.
Right, heard counsel for the parties issue notice. Returnable 4 weeks. Mr. D. Bora for
3, 5, and 6.
3, 5, and 6. MSH as Borua for respondent 1 and 2. Mr. R.K. Talukdar for accountant general.
Minor.
And who is there for state?
I'm for 1.
You are for 1.
1.
Oh, revenue. Okay, 1. H. Borua for 2 and 7.
Yes.
And you, Sharma, who's there for state? Mr. D. Bora.
3, 5, and 6.
3, 5, and 6. And who is number 8?
Divorce was second.
And who are you?
Subsequent marriage was second.
You are the second wife. You should note, since the respondents represents, since the council represents respondent 1, 1 TO2, 6. Notices are waived, extra copies be, 1 to 7. Notices are waived, extra copies be furnished within a period of 1 week from today. Steps on respondent 8 by register force AD as well as usual course. And extra copies be furnished to the council for respondents 1 to 7. Matter be listed after returnable date. Pendency shall not be a bar for?
Provisional compassionate payment.
How can it be granted in the face of?
There might be a dispute between the private respondent and the petitioner.
Divorce, but she is remarried.
No, my lord.
Pendency shall not be a bar to ameliorate the grievances raised by the petitioner before this court.
13.
None appears, passed over.
14. Is also non-payment of family pension, my lord. The pension proposal pension pending, my lord, page 29. Before the office of the commissioner, my lord. Since 2019, my lord. No step has been.
Notice.
My lord.
Third council for the parties issue notice. 4 weeks. Issue notice returnable 4 weeks. MS
J. Bora appearing on behalf of S.
Jibra
Doctor.
appears on behalf of
S. Doctor.
S. Doctor. For respondents,
1, 4, and 6.
1, 4, and 6. Mr. C.K.S. Borua for 2
And 5.
and 5.
Yes.
H. Borua for 3,
3 and 7.
3 and 7. And for 6,
6.
Also all of PNRDT.
1, 4, and 6, Lord.
1, 4, and 6. Since the council represent respondents, notices the waive. Extra copies will be furnished within a period of 1 week from today. List after returnable date.
Obviously.
Item 16. Lordship, being agreed with Lordship, rejection of 4 numbers of houses, Lordship, relating to rejection of 4 numbers of houses, Lordship.
What houses?
Lordship, relating to final bill of LTC, Lordship. This is have been preferred, Lordship. The fact is that I was a grade 1 stenographer under Lordship Principal Just Family Court, Lordship. At the part of my retirement, Lordship, I applied for Lordship LTC, which was allowed, Lordship, to travel some places, Lordship. And after returning, Lordship, I submitted the final bill. And from them, Lordship, 4 numbers of four houses were rejected, Lordship. Houses are at place, Lordship, 30 to 33, Lordship.
There is no appeal.
Appeal, Lordship.
There is no appeal. There is an appeal at forum.
Appeal forum, Lordship.
Who rejected it?
The principal judge, Lordship. Principal judge family court, Lordship. Page 30, page 44,
So,
Lordship.
You have to serve copies on the Standing Council High Court.
Page 44.
Heard counsel for parties issue notice. Will not issue notice. Better to get instructions. You serve copies on the Standing Council and come back.
Lordship. Today itself, Lordship.
Today itself.
Right.
Come back. We'll call it up after a while.
Item 18. Lordship. My senior is in late in board number 1. What's a matter for timing, Lordship?
We'll issue notice at this time.
WPC number 3744 will be listed along with this in petition.
Heard plenary council for parties. Petitioner is aggrieved by where is the order? Impugned order.
Page number 72.
You have filed some appeal. Yes, finance. Please get instructions on this, whether any appeal has been filed and if so, what orders have been passed. Third counsel for parties, Finance Department, Standing Counsel will obtain instructions with regard to any appeal that may have been preferred by the petitioner in terms of the order dated 12/8/2024, whereby the disciplinary authority had imposed penalty on the petitioner. Stop. Let these instructions be placed before the court within 2 weeks. MSH Borwa, counsel, represents all the respondents. Extra copies be furnished. You furnish extra copies within 2 working days.
Lordship, number 37.
No, after returnable date. First, you furnish extra copies. We'll have it on 22nd of August. Get your instructions here. Yes.
Also, the petitioner also, because of non-compliance of a transfer order advance lawsuit, he was subject to several harassment lawsuits. He was placed under suspension. Initially, lawsuit, the transfer order was interpreted by a lawsuit. I was given some time, but because the doctor had advised me to for surgery, but I could not take the risk of removing my reproductive organs because I could not become a mother. That is why lawsuit my this leave lawsuit prolonged lawsuit. Ultimately, lawsuit there's an inquiry. In the inquiry, lawsuit nothing was found against me, and in the conclusion, the inquiry officer has stated that she may be permitted to join and then pray for leave for her medical treatment. So the inquiry officer must have been convinced that I was under medical emergency. Lawsuit, I was reinstated in service. Lawsuit on lawsuit 21/11/2024 lawsuit, and I resigned. But lawsuit, my period of suspension during the period of suspension has not been regularized. Even I had 215 days of earned leave to my credit. That period of that particular period, lawsuit, the salary has not been released to me. Now, lawsuit, I have completed 12 years of service. All other incumbent lawsuit, they have been given financial upgradation, MSAP. After completion of 10 years, I have not been given that. And lawsuit, my service has not been confirmed.
Confirmed?
Yes, lawsuit. And lawsuit, my ACR has also not been reported from my very date of initial appointment. And against the order of penalty of censure, I have also prepared an appeal lawsuit.
Who's for the Finance Department? Finance?
Lawsuit, we have served copies, they are standing copies.
Finance.
Names have been shown in the court.
Who is for GST or finance?
SC
Yes.
there and Vikram Sodari.
So who did you serve copies?
I have not seen the notice. Yes.
Third counsel for parties. Mr. B. Gogoi, learned additional AG, will obtain instructions with regard to the grievances raised by the petitioner. Stop. The petitioner, the counsel for petitioner submits that because of prolonged medical ailments, she was required to be frequently on leave, and because of which she was placed under suspension, although subsequently reinstated. And but her period of suspension under suspension was not regularized. Her services have not been confirmed, and she had also not been given the financial benefits under MSCPS. Stop. The B. Gogoi, Mr. B. Chaudhary. Mr. Chaudhary will obtain instructions in the matter and apprise the court on the next date fixed. In order to enable him to obtain instructions, extra copies be furnished. MSR Soikia for respondent 4. On behalf of S committee. List again on 20
Yes.
20 August.
My appeal
Ec-
filed on 10/2/2025 also.
Hmm?
My representation and appeal also is pending. That may be pendency also may not be valid.
Pendency of the writ petition will not be a bar for disposal of the representation / appeal dated
Appeal is dated also 10/2/2025
10 to 2025
and representation is 1/7/2025.
and representation 1/7/25
2025.
to be disposed of by the respondent authority. The extra copies within 2 working days. Yes.
Okay. Item 20.
In the compassionate appointment case, Your Honor, petitioner was minor at the time of death of his father. And when he became major, then he applied for the post, but DLC rejected his case.
Is not applicable.
Yes,
How can you, how many years? After how many years?
20 years.
But in some cases, this honorable court has said that if minor get after getting majority, he applied for the post, he can be considered.
Which judgments?
One case is Rajesh Nath versus State of Assam.
Give us the copies.
I will appraise.
You don't have the copies.
Right now, I don't have because we have annex one copy where stated
Tribunal order.
tribunal order.
No, you mentioned about some orders being passed by this court.
That was,
You bring those orders?
yes, I will appraise it.
We
When?
have our own court order, Lordship.
Hmm.
This is WPC 6916/2023 and order dated 12/12/2023, Lordship. Passed by coordinate bench of this honorable court,
WPC?
Lordship. 6916
Of
2023.
23.
Yes, Lordship.
Order dated?
Order dated 12/12/2023. And here is also the same case where it has
You-
been observed,
You
Lordship.
produce this, you bring these copies on record,
Yes, sir.
place it before the court.
And this is our Lordship. They are not entitled, Lordship.
You place a copy. When? When can you place it?
2 days, man.
2 days. So 6th. 6th of August.
Problem.
MS M. Bhattacharya appears for the respondents.
Item 21. May please, Sir Lord. Lateral district professional appointment, Lordship. This is the second round of litigation, Lordship. Earlier order is at page 41 and Annex 38. Commissioner, this was not placed before the DLC in spite of level and observation.
My lord, my submission will be let Dimahasao take instruction, my lord. Direction was on Dimahasao, the last page of
Hmm.
the writ petition. Page 41.
Yes.
Let them,
You kindly allow me some time.
But why are you coming now after 10 years? The order was passed in, when was it passed?
Distance from the authorities. Lordship.
Huh?
2015, they could have filed in contempt though.
When was it, when was this order passed?
2/9/2015. Lordship.
Huh?
2/9/2015.
2/9/2015.
Delay and Lecher's part is there.
So anyway, get your instructions. You serve extra copies within the course of the day. The respondent counsel for Dimahasao will obtain instructions as to the compliance of the directions contained in the order dated 2/9/2015 passed in WPC 3781 of 2015.
I am just
Mr. R. Dhor appears for
the government matter.
the state.
2 weeks.
2 weeks. 22 August.
Supplementary for motion item 47.
Wait, please, your lordship. My lord, may I kindly pass over the matter? My senior is on decks.
Inter-departmental transfer, lordship, from one department to other department. That is the case. After 3.5 years of being there in the other department,
No, let him come after some time.
For order item 23.
22 to mention only.
May I please, your lordship? Lordship, Mr. R. Prabhuja is appearing for this matter. He is on legs in court 1, your lordship. Matter may you pass over a time being, your lordship.
See, every matter can't be passed over, so you should have some instructions other than making a submission that pass over. Because we also have to complete the list. If he's not available, get his instructions, what instructions he has. You are appearing, he is appearing on whose behalf? Mr. Nath, you are appearing for?
But for the respondent number 6, he is Commissioner and Secretary Home Department.
6.
6.
Now, on the last order, Commissioner Finance was implemented.
Yes.
Who has filed it?
Who has filed? For the respondent 7.
As part of list.
You have received copies? No, you said affidavit has been filed.
Affidavit has been filed by the state respondents filer.
No, respondent 7.
7 has been filed. Mr. B. Gogoi has entered appearance on his behalf.
Okay. All right, call him.
Four.
Lordship, I am appearing on behalf of Senior Advocate Chinmay Chaudhary. I represent the petitioner Vikas Thakur. We had filed an additional IA on 22nd that has not been listed for today. If the lordship permits, I would like to check it with the registry and then
You have filed an IA.
yes, lordship.
Do you have the number?
Yes, lordship. This is 9261 2025 filed on 22nd of this month, and we had duly served copies to the respondent party.
All right, so it is submitted by the council for the petitioner that an IA has been filed, being IA number
9261
9261
9261
of
20
2025
on 22nd.
on 22nd of July. Stop. The same, however, is not listed. Council submits that the matters be listed along with the said I. What is the I for?
I'm not very.
All right. MSG Bora
For respondent number 1.
for respondent number 1. The registry will verify, and if the I is submitted, has been filed and is raised and has been registered and is clear of defects, the same be listed along with these matters next week.
Title column, Agriculture University has been sold. Lordship. Otherwise, they were the main party.
You are representing whom?
Agriculture Department.
Department.
Assam Agriculture University has the separate council.
All right. Please.
Lordship, apologies. The latest IA
repeats the same thing that we have said in the previous IA, like which is listed for today.
Let the IA be there. If you want to have filed it, let the IA be placed, connected.
Only five.
Hmm. Where is the direction?
My lord. Page 11 page, my lord, on 17, my lord. Paragraph 17. Page number also. Sir.
Who's for the respondents?
My lord. My lord, can you see the public affidavit, my lord? They received the dusty service, my lord, on 10/6/25, page 28, my lord. My affidavit. Page 28, my lord. And the body itself, my lord, signed by the PA of the condemned order. Quite of several representation, my lord.
Yes, Government Council. Who's there? Mr. Nath. We request you to obtain instructions from respondent 1. At least.
I'll see.
And if respondent 1 has already debited office, then the officer who's in now replaced him.
Lodge.
You serve an extra
I'll
copy to
take a-
Mr. Nath.
Lodge. See.
Heard counsel for the petitioner. In spite of notices being issued and steps taken to have been stated to have been undertaken by the writ petitioner,
Yes.
the respondents have not appeared before this court. The counsel for the petitioner submits that dusty service has also been given effect to. Has been effected. However, the respondents are not before the court. Mr. D. Nath, Senior Government Advocate, being present in court, the court has requested Mr. Nath to obtain instructions through his office regarding the compliance of the directions contained in the order dated so-and-so, passed in WBC so-and-so. In order to enable Mr. Nath to complete his instructions, extra copies be furnished. Let this matter be listed again on 22nd
Lordship.
of August, enabling Mr. Nath to complete his instructions. Copy of this order be marked to the office of Mr. D. Nath, Senior Government Advocate. Registry will also reflect the name of Mr. D. Nath, D. Nath as a counsel for the respondents. List on
22nd.
22nd
22nd
August.
August.
Second?
You want it later?
No, earlier.
Earlier. Earlier is, can you get it by 13th?
13th. I'll try. Madam.
All right, 13th will do.
Okay.
List on 13th.
No problem.
Supplementary list for orders item 48.
None appears for the petitioner. Although permitted by the earlier order dated 27/6/2025, the petitioner was permitted to, although by earlier order dated so-and-so, petitioner was permitted to take dusty service on sole respondent. Office note dated 28/7/2025 reflects that dusty service has not been taken on the sole respondent. List again after 4 weeks.
Typing item 16.
Yes.
I am appearing for respondent 3, Lordship. I have been informed that.
You are for the airport.
Yes, Lordship. For TJ Mahanta,
You get instructions,
Lordship.
give him extra copies. Mr. P.P. Dotto, learned
I'm on behalf of TJ Mahanta.
counsel, appears on behalf of Mr. T.J. Mounto, senior counsel, standing counsel, Guwahati High Court. Will obtain required instructions in the matter. Let extra copies be furnished within 2 working days. List taken on 22nd of August. MS U. Sharma for
1 and 2, Lordship.
respondents 1 and 2. Yes.
Lordship.
Daily list for admission item 26.
May I please,
Yes.
my lord? My lord, may kindly peruse the last order. Here, in this case, my lord, argument has been concluded by Honorable Justice U.K. Nair.
No. Before appropriate bench.
Yes, my lord.
Yes, ma'am.
In view of the order.
This
Order dated,
This court is not inappropriate.
No, because hearing is concluded.
hearing is concluded. ma'am.
To that extent,
Yes,
it is
yes,
inappropriate. 23/7 by order dated 23/7/2025. Coordinate bench, it is seen that the coordinate bench had concluded the hearing. Stop registry to take steps to list this matter before appropriate bench accordingly.
Deeply blessed. ma'am.
Wait, please, also. That pertains to my lord arrears salary balance. What may kindly see the last order?
Then
Now the government sent it to the finance department for release of for sanction of the arrears salary.
yes, finance, who's there? Finance, standing council, finance. Third council for parties, MS,
Deca.
V Deca appearing for
For
elementary.
elementary education.
Elementary education is placed before a communication received from the Office of the Director, Elementary Education, that the area salary proposal along with non-royal certificate for an amount of rupees 2,32,618 for the period 23/3/2010 to 15/3/2012 has been forwarded to the Office of the Director, Office of the Secretary, Government of Assam, Department of School Education, Learned Council for the Elementary Education. On further instruction submits that from the Department of School Education, the proposal has already been forwarded to the Finance Department. Matter is pending before the Finance Department. And Counsel for the Finance Department, Mr. R. Borpuzari, will obtain instructions and place it before the court within 2 weeks from today. Yes, Mr. Borpuzari. Any instructions here? Arrear salary. It has been sent to the Finance Department.
Yes, but if it is sent to the finance, it will be sent from the government level. If I have that, my lord, proposal number, definitely. Here it is not, my lord, known. The fact that it has been sent to the finance, my lord, it is not transpired here.
You find out, may be available.
No, my lord, we get proposals pan Assam, my lord, it will be very difficult unless and until they give us a precise proposal number.
The Council for the Education Department will furnish the, what is that e-file number?
Yes, my lord, proposal number.
Proposal number to Mr. Borpuzari, so that the Standing Council Finance, Mr. Borpuzari, can apprise the court the status of
Absolutely.
the proposal being forwarded by the Education Department. List after 2 weeks.
Date may.
You furnish, when can you furnish?
Within 10 days.
10 days. Today.
Not.
You call up your director's office, get the proposal number, give it to him. Yes.
Any date be fixed after 15th of August?
20th
20 month.
of August.
Highly honest.
Obliged.
I think 23.
23 Q. Yes. Any instructions?
Yes, my lord, we have received the instruction, my lord.
You
My
bring it
lord,
on record. Bring
Yes,
it on
my lord.
record
Yes, my
within
lord.
2 weeks.
Yes, my lord. We'll file an affidavit.
Let him bring it on record.
My lord.
List on 20.
20.
20, enabling Mr. R. Borpudari to bring on record the instructions received from the
My lord, I am representing, my lord, contempt number 7, newly implemented. R7,
contempt number from the respondent number
respondent
7.
number 7, my lord.
Yes.
I am obliged, my lord.
Here, Lord, I received the instruction that from the date of application, it has been sanctioned, Lordship, as per
Hmm?
office memorandum.
Which one?
The family pension, Lordship, for
Okay.
the freedom fighter, from the date of application. She made an application in the month of 1/9/2015. From 1/9/2015, it has been changed.
Lordship,
She is claiming the arrear now from the date of death. That it will be from, as per our OM Lordship, it will be from the date of application,
Where is that OM?
Lordship. Page 9, Lordship.
Page 9 of these ones.
Lordship. Lordship, page 7, sorry. 5.2, Lordship, transfer of pension to spouse or daughter, Lordship. Then 5.2.2, the dependent pension shall be paid from the date of application by the spouse, daughter, and not from the date of death of the pensioner. And she had applied in the month of 1/9/2015. The back
No,
that
5.2.
5.2.1 is also there if she doesn't made an application within 6 months.
No. 5.2 says it has to be applied within 6 months.
Yes. If it
But-
is not,
But it doesn't say it has, it will be,
if doesn't made thereafter, Lordship, it has to be from the date of application.
where is that?
That 5.2.2.
Okay. Yes.
Lordship, in this regard, this honorable court comes to a conclusion and pass the last two orders. And accordingly, this honorable court directed the respondent authorities to apprise this court considering to release the pending pension.
Their guidelines say that it shall be from the date of application.
Lordship, kindly see page number 21
Of?
of my writ petition. I have filed the application and accordingly the state government authority had forwarded on 23 February 2016, serial number 5, attested copy of application dated 2/6/2006 of Jaba Chakraborty. All necessary particulars were forwarded.
So your pension is now released from which date?
From 1/9/2015, it is to the, she made an application to the state, Lordship. This is the state contribution, Lordship. This is the state, and for the central, Lordship, it was sent to the central on page 17, Lordship. To the petition, Lordship.
Lordship, before me, my mother was drawing pension from the state and the central. After expiry of my mother, immediately both the state and central should allow my pension, and accordingly the state government allowed my pension from the date of my mother, but central government
has not allowed the same.
We have sanctioned it from 1/9/2015.
Hmm?
We have sanctioned it from 1/9/2015. Along with the arrears from 2015. It was sanctioned in 2016, but we have taken 1/9/2015 as well from that paper.
This is to be disbursed by the government of India
Yes,
only.
yes, and state government is giving their share from 2005.
Where is the scheme?
Lordship,
Where is the notification or OM of the scheme?
this is for the disbursement of, this scheme is for the revised guidelines for payment of.
This is for revised, but
Revised.
the fact that it has a central and a state component,
Lodge.
where does one find it?
State one, it will be by this, with the state government. Lodge.
No, yours, are they two separate
Yes, your lordship.
disbursements or one?
Two separate. Huh?
Lordship, there is one notification.
Where is that notification?
Yes.
Why don't you bring all these on record? These are relevant. Yes.
Yes, state was. Page 22 is the sanction of the state of the writ petition.
Where is the procedure? Not written here. Which part of the notification?
No separate notification in my way.
The state sanction is at page 22, Lordship, of the writ petition, state sanction.
No. First show us that this is a scheme where there is a state and a central component.
Lodge. That,
Show us if you have.
today I don't have lodge.
Oh. All right. You show us on, bring it on record if you have.
Lordship, give us some time, Lordship.
13th. Can you get it by 13th?
Okay.
List on 13th. enabling the learned CGC to bring on record the particulars of the scheme. What is the scheme called?
Freedom fight, Swatantra Senani, Swatantrata Samman.
Freedom Fighters Scheme. Freedom Fighters Central Scheme. List on 13th.
Maybe the lordship. Malad, the petitioner, he is working as a ship manager, technical audit in the All India Limited at Duliatan, Malad. Not an impugned transfer order had been issued on 23rd of this month, Malad. Lordship will find it at page 19. At serial number 2. Sujit Bora, ship manager, technical audit, has been transferred to ship manager materials. My lord, there is a policy for their transfer, my lord, that your lordship will find at page 20, HR policy and scheme.
Where is that?
My lord, it is at starts from page 20. Lordship may come to my page 21. As per this policy, my lord, at 6.2.4, the process of inter-departmental jobs rotation will be as follows. Personnel department shall provide a list of executives who have committed more than 3 years, 5 years in the current department and due to rotation by 30th September. Till such time, the information is available in the database. The list shall be generated at the concerned department. HOD in consultation of group head shall submit the transfer policy proposal, to personnel department for processing the transfer. But this has not been done. And secondly, at 6.215, inter-departmental job rotation in field up to grade F shall take place normally in March and April. This has been issued on July on approval of transfer by the head of the fields. Now, my lord, the department where I have been transferred, I worked there for 14 years. After that, but I filed an application before the authorities to transfer me any other department except the contact and process. Upon receiving that representation, the authority was pleased to transfer me to other department. That is at page 18, next 1. So my grievance is that except this contact and process department, they may transfer me to any department, my lord. And regarding this matter, I have also filed a representation, my lord, on 24th, my lord, of this month at page 24.
You are agreed by which order?
I am agreed by the order dated, my lord, at page 19.
Page 19.
My lord, 23/7, 25, my lord. And except
You are transferred from technical and audit
to the contact and process.
No, it says materials.
It's not contact and process ultimately.
So what is wrong with contract and purchase?
But if I had been there for 14 years, there is a stagnation, my lord. There is no promotion, scope in that department, my lord. So I am agreed, my lord. And regarding the policy of transfer, they have to abide by the policy, my lord, HR policies and scheme, which I have lordship shown at page 21.
No, lack of promotional avenue is one aspect.
Yes, my lord.
But you are now aggrieved by the transfer order.
Transfer order, my lord.
What is wrong with the transfer order?
Transfer is regarding page 21, my lord. The policy, HR policy and scheme. But this policy, these transfers are done. HOD in consultation of group head shall submit at.
It must have been done.
No, not done. I have done all this, madam. This has not been done. And
yes, get your instructions.
It's there already. I have taken the paragraph's comment also, and the instructions are also there. This is otherwise an inter-departmental transfer. Now, if a lordship will just come, the illegality that he is referring to is non-compliance of the scheme regarding that HOD's approval. That your lordship will find this document I have placed, that approval of 2 pages document.
Yes.
Lordship will see The HOD is the Chief General Manager, HR Development. Approving authority is the Executive Director and the signature. The approval is there. And this is not a transfer regarding only him. This is regarding three employees and it has been done. And in fact, that policy itself says any person who has crossed more than 3 years is liable to be transferred. And this is the administrative function of transferring from one department to another department. Another aspect that he has suppressed, his appointment is in the material department. His initial appointment is material department. So at any point of time, for exigency of service, for requirement, administrative function, he may be transferred. What is the wrong there? And the only illegality that he's pointing out is supposedly that permission was not taken, approval not taken. I have shown that approval is there.
Yes.
And my lord, these
And his department is material department.
transports are done in the month of March and April, my lord.
That the word is normally.
Yes.
For
Yes,
exigency of
normally
service, it can be done.
they
That
comply
cannot be a ground to non-suit.
What is that exigency of service?
No, I am saying this is an administrative function, lordship. It's not that he has been targeted or something like that. 3 years he was there in that department. Now a rotational transfer has taken place. 3 persons have been transferred. And he is transferred to his parent department only, where he is appointed. That I have also placed, lordship. Page 8 of the compilation.
Dispose of this representation.
I think that has also been done, your lordship. If your lordship will see that compilation of documents, page 10,
Then.
the last page. It has been communicated to him.
What is the date of the letter?
28/7/2025, lordship. That compilation of papers that I gave, page 10, the last page.
No, his representation.
His
My lord,
representation.
At page 24, my lord. 24, and the phase 1 is at page 25, my lord.
Which representation are you referring to?
My lord, both the, my lord. Annexure 5 and Annexure 6, my lord.
So why are you giving two representations?
Now, initially, I gave this one, my lord, the first representation.
24/7/2025 is been considered.
Any other department except this mounting and parcels. And in the second representation, my lord, I have quoted the policy, my lord. The which policy they have done, my lord. That they have violated their own policy, my lord, SR policy. These transfers are not done on March, my lord. It's for in the month of March, and I have been transferred on July.
The 24/7/2025 representation is considered. Subsequently, he filed another representation 27/7, wherein he stated that the transfer policies clause 6.4, 2.4 is not been complied with, which I have shown that the approval is there from the highest authority.
6.4.
You show us you tell us the reason why. Normally, as per your policy, it should be in March and April.
Normally, the word is normally.
Yes, normally. They comply by the normally what, my lord.
Lordship will
Now,
see.
the ground for which you are challenging the transfer order is also hardly anything legal about it.
My lord. My lord, I worked there for 14 years.
So where else will you work? If you don't like to work, you resign and go.
And lordship, I received this letter today, my lord, in the morning. Lordship, may kindly go to this, my lord.
What letter?
My lord.
Lordship will also see page 5 of the compilation. His appointment is in the materials department.
No, that, see, either you say that his appointment is in material, so he is going back. Or.
What I am saying, this is a normal administrative function of rotating, shifting, transferring of employees within the departments.
6.15.
There is nothing
We
illegal
will
about it.
examine it. We done.
Yeah, I'll file my affidavit.
State.
I'll file my affidavit.
We'll
Otherwise,
put
he's
this
already
on
been
the
released,
interim.
your lordship.
Meanwhile, we'll let us see what happens.
So status quo will depend, my lord.
No,
No status quo.
no, because you see, you have to show us that it is
My lord,
strictly in
my lord,
violation
let
of.
me, my lord, answer, my lord, why I have been transferred on the month of July instead of March.
That is the prerogative of the department. You are within your rights to find out the reasons why 3 of you are transferred. Maybe there is some material.
My lord.
I'll file my affidavit. I'll bring.
Till the
whatever.
affidavit, my lord. Let us cover with
No, lordship. It's already been released on 29/7.
6.2.1.
You see, we are issuing a notice on the interim prayer. We'll see what happens. Third counsel for the parties. Petitioner is aggrieved by the order dated 23/7/2025 passed by the Chief General Manager within bracket HRD of the respondent Oil India Limited. By the said order, 3 officers, including the petitioner, was transferred from the departments mentioned therein to the departments which is also reflected in the said order. Petitioner's name appears at serial number 2. Issue notice returnable 4 weeks. Mr. Sharma, A. Sharma appears for
All the respondents, Lordship.
all the respondents and accepts notice, therefore notices are waived, extra copies will be furnished within a period of 1 week from now. Notice on the interim bread. Returnable on 3rd of September.
My lord, a short date will be given on the.
And they will make it returnable 3 weeks going.
Lordship may fix a date, my lord.
22nd August.
Lordship may also record the policy decision, my lord, in this
Not
order.
necessary. Let the respondents complete their instructions and file necessary affidavit. And in the meantime, if so advised.
Yes, Your Lordship.
We
The
Obliged.
tendency of this representation shall not be a bar to dispose of the representation.
They've
It's
already
already
disposed.
disposed of.
They've disposed of your
No,
representative.
my lord, the second one, my lord, that has not been disposed of.
Second one is
Pendency
only,
of the writ petition will not be a bar to dispose of the representations. Subsequent representations stated to be filed with the writ petitioner.
but he says that it is only in addition to that earlier represent. Anyways, Lordship, we'll look into it. Obliged.
I think 29.
Kindly see order dated 21/5/2025. It's
Yes.
about 4 years, my lord, from my
What is the amount that you want? What
amount
are
by
you claiming?
12,48,969.
Towards?
12 lakhs
For
48.
what purpose?
It is total retirement benefit. The terminal benefit. It is not disputed by the.
How much have you released?
My lord, only 20,000, my lord. We could not pay.
And that is on
We
the
are,
month
we
of
are
October.
regularly asked.
Go and file a suit. Money suit.
That will be better, my
My
lord,
lord,
because
my lord, a specific direction may be given to the
Direction, who will comply with it?
municipality, man.
From where? They say there is no money.
My lord, in earlier case, my lord, there are some other cases, my lord. This is WPC number 5345/2022. Earlier, I have submitted this order. During the pendency of that case also, they released all amount of that person, my lord.
There is no dispute that this is the amount.
no, there is no dispute, my lord. Because, but,
What steps are you taking to release this?
my lord, we are in deficit. I have submitted on the
lord,
last
it's-
occasion also. This is
My
the
lord,
recent.
the chairman of the municipality are receiving salary, or all other employees, they are
No,
receiving
my
their
lord,
salary. my
that's not
Yeah.
true.
Whether so, in this regard, my lord, they may file affidavit, my lord, till date, whether they are receiving the chairman of this municipality receiving salary or not.
No, chairman receiving salary has got nothing to do with your retirement benefits. Your retirement benefits, you are concerned with that. You are not concerned with somebody's salary.
My lord, since they have the funds to manage all other employees.
You make a statement on the basis of some documents.
No, I mean, we are
You
regularly.
show us that yes, they have funds, but they are not releasing it. We'll pass orders.
No. My lord, sometime maybe granted, I will file.
Whatever you want to
Okay.
file,
Yes, madam.
but there has to be some.
In fact, we are requesting the Director Municipal Administration regularly to give us some funds so that we can release the money payable to the petitioner.
You get us an audited certificate
Audited certificate. Well,
of the position. Heard Council for Parties. petitioner is agreeing that the terminal benefits payable to the petitioner to the amount of rupees.
This is better.
Amount of rupees 12,48,969 has not been released. Stop. It is the submission of the council to the petitioner that this amount is not disputed. However, they have not released the said amount. It is further submission of the petitioner that there are sufficient funds available, but they have declined to release the said amount. In 2022, you submitted a statement, and there establishment expenses were shown to be 55,573. And in 2025, administrative expenses,
Administrative.
it has gone up to 30 lakhs. How? And the chairman signs this certificate without any date.
My lord,
Why?
I'll get an audited certificates of this.
Not only audited, you get an explanation how from 55,000 in March 2022, it has jumped up to 30 lakhs in March 2025. Administrative expenses.
Yes, my lord.
Get an audited report along with the fund position
Well,
by the next date. Respondents will file audited accounts and a report by a certified auditor showing the financial health of the municipal,
Karimganj Municipal.
Karimganj Municipal,
Now my Sribhumi Municipal.
Sri Bhumi Municipal. List on 20 August. 20 August.
Obliged.
Respondents 1 and 3.
Mr. D. Bora for respondent 1 and 3, A. Dhor for municipal.
In this case, Lordship, my 2 annual increment has been stopped after departmental inquiry.
Lordship, we have received instruction, Lordship. Kindly allow us 2 weeks' time, we shall file the affidavit. And Lordship, record is also necessary. Lordship may pass an order to that effect.
Mr. F. Z. Mazumdar for the petitioner, and Ms. M. Bhattacharya, additional government advocate, senior government advocate for the respondents. Ms. Bhattacharya submits that she has received instructions in the matter. She prays for 2 weeks' time to file the affidavit. Is further submitted. Prayer made is not objected to by the petitioner. Therefore, matter stands deferred to be listed on after 2 weeks. The relevant records pertaining to the present, pertaining to the issues raised in the present petition.
Yes, Lordship. Disciplinary
also be-
proceedings.
They also be called for and kept ready for perusal of the court if the need so arises. Twenty-seventh,
Lordship.
27th, 8th, Lordship.
27/8.
Deeply obliged.
31.
8 players. Can you see the order dated?
On last occasion, Lordship has passed an order directing us to file the affidavit or if failing which method the record is to be produced. But somehow the affidavit could not be filed. I have received the records, but records with me, below. But if Lordship kindly gives us some time, my lord, 3 days, 4 days time, my lord, we can bring it on record. Otherwise, the records are available. That's what I was thinking about India. I will do this. India, I will do it.
You want to file the affidavit?
But Lordship may kindly permit us.
Have you received your instruction?
Yes, my lord, I have received the instructions as well as the record. Record reveals that my lord, the promotion order was given and it was a conditional order that if some court case or any inquiry is pending, then it will not be given effect. The report from the vigilance, my lord, we got on 13th of March. So the vigilance shows that there is a vigilance inquiry is pending. And he has filed the writ petition that the order passed by the authority is not served to him. I have the record, my lord, it was given to him subsequently. The inquiry is still pending, my lord.
What do you say, Mr. Counsel?
Lordship, court order was to file affidavit, Lordship. He may file affidavit, Lordship, by fixing a date, Lordship, short date. I will reply, Lordship.
Pursuant to the deference to the order dated 18/6/2025, Mr. D. Nath, Senior Government Advocate for the state, submits that the
Copy this. Copy my heavy query to back to public.
No, I think it's very good things.
My application was.
No,
records are available as well. Records have been received along with the comments necessary for filing the affidavit. However, the affidavit could not be filed. We praise for further 2 weeks
Lordship.
time to complete the instructions, to file the affidavit. Fair enough. Considering the issues raised in the present writ petition, this court is of the view that the affidavit on behalf of the respondents would be necessary. And since the senior government advocate submits that the affidavit can be filed within 2 weeks, let the matter be listed again after 2 weeks. Records received be retained by the office of the senior government advocate.
Lordship.
Date may be fixed, Lordship.
No.
Otherwise.
Let him file it
No, no.
within 2 weeks.
We'll file.
Lordship, then, Lordship, if it is not filed, Lordship, within 2 weeks, Lordship.
If it is not filed, you make a mention. We'll issue direction.
Lordship.
Huh? Because after he files, you may like to file a reply.
Lordship.
Oh, Lordship.
It please a lordship. Lordship, here I pay for an accommodation the next week, Lordship. Accommodation in the next week.
Lordship, 2 weeks time will be rendered because they gave the extra copy only on 17th of this month. Time may be granted.
After 2 weeks,
1 week, Lordship.
matter be listed after 1 week on the request made by the counsel for the petitioner. Mr. D. Bora and S. Doctor appears for the respective respondents.
Obliged, Lordship.
Lordship has received the instruction, Lordship, may grant us 3 weeks time to file the counter, Lordship.
Yes,
Yes, your Lordship.
Mr. B. Chakraborty, learned counsel for the petitioner, submits that he has received instructions on the matter. He prays for 3 weeks time. File the affidavit. Prayer made is not objected to by the counsel for the petitioner. List after 3 weeks.
Obliged.
34.
May it please the Lordship. Lord, this is a penalty of withholding of 1 increment with cumulative effect was imposed. although, my lord, we don't generally pray for stay of the penalty order, but going by the illegality that has been done by the respondents here in this case, my lord, what happened in this matter for 2018 to 2021, the petitioner was directed to cause an audit of Khairasghat College, not Lakhimpur. Now he did the audit and he found latent, my lord, embezzlement of money by the principal, an amount to the tune of rupees around 15 lakhs. Now that principal, then, my lord, the petitioner submitted preliminary objection statement during the course of his audit. Now that principal, my lord, lodged a complaint against the petitioner. And pursuant to that complaint, they issued a charge sheet against me. 3 charges were, my lord, leveled against me. All the 3 charges are on the face of it unfounded. If you just take your lordships with the charge sheet, my lord will kindly have page 100.
Pleadings are complete here.
My lord, no. My lord, I am pressing the interim prayer of stay of the penalty order, my lord. Normally, if we don't pray.
What is the penalty?
Penalty is withholding of increment that your lordship will find. Withholding of 1 increment with cumulative effect and with warning. Page 129.
No, you
Because
are praying for only quashing of the penalty order.
Penalty order, my lord.
That
Because
will
the charges, if your lordships kindly appreciate page 100.
Are you challenging the proceedings?
Yes, because entire proceeding culminated into penalty. So I am aggrieved by the penalty order and there are grounds of, my lord, procedural violation as well as violation of principles of natural justice. My lord, I am not harping on at this moment and I am not harping on that.
No, your
on the
prayer
face.
does not have, you don't have a prayer for setting aside with the findings of the inquiry or anything like
No,
that.
it's not required because everything culminated into the penalty order. Once the penalty order goes, everything goes, my lord.
Therefore, we are saying that granting you an
Today-
interim will amount to granting you a final order now. That's your prayer.
No, if in a way it's true, but I'm on the prima facie case, my lord. If I can satisfy your lordships, my lord, lordships has every power to, my lord.
No. What we want to know is the relief you are claiming here is setting aside with the penalty.
Penalty order.
This is the only relief. You are
Yes.
not. There is no challenge essentially to the proceedings or
Proceeding
ancillary.
in the pleadings I have, my lord, all the grounds I have taken for
But
my
there
lord
has to be
regarding
a
the
specific-
publicity.
But don't you think there has to be a specific challenge to the proceeding?
Look, normally what we do is that if the penalty order is imposed pursuant to a charge sheet, we challenge the penalty because the charge sheet and inquiry report merges with the penalty order ultimately. So that is how the things are done. So if
at
you
this
if
stage to grant you an interim order will amount to granting you a final order. That is the relief, only relief you are praying for.
if at the time of final stage your lordships find that I don't have any merit in the case, then the lordships can dismiss my interim order gets vacated. But the thing is that, my lord, if your lordships kindly appreciate the charges for a moment, 3 charges, my lord. First charge is that you have exhibited reluctance to carry out instruction from your superior officers. So this charge is relatable to a letter of 5/4, wherein I was directed to appear before my superior officer on 7/4. I in fact appeared on 7/4. So how reluctance comes? Had I not appeared on 7/4, then come reluctance, page 100. That is the first charge.
I think we should hear the matter because if we have to decide on the charges, we are getting into the merit.
Look, I was just trying to place a prima facie case before your lordships.
Prima facie.
And insisting your lordships to pass some order.
We can give you an interim order that we will go for a very early hearing. That is the only interim order at this stage we can give.
Like if lordship looks at the earlier order, last order, lord.
Because last order it has been provided, the interim order will be considered on the next day. My lord.
Quite right.
Last order, last line, lordship. It is made clear that any action taken in the matter during the pendency of the said petition shall be subject to further orders.
That is already there.
That
Already
there,
there,
but
lord.
despite that, this honorable court has recorded considering my interim
We'll keep
prayer.
it alive.
Yes.
We'll keep it alive.
Yes.
We're not closing your interim prayer.
In that event, if my lord,
we direct the respondents to complete their pleadings.
Fine.
Let us attempt to dispose of the matter. If for some reason it lingers on, we may consider passing interim orders at that stage.
then my only prayer would, before your lordship would be that, my lord, if the matter can be, because otherwise he is absolutely honest officer, my lord. Why I am saying so? He detected the, my lord, misappropriation of money and he has been penalized, my lord. This is absolutely absurd. That too pursuant to a complaint by the principal, who was later on suspended and penalty was imposed. That principal on the basis of my report. And the complaint she filed, it was forwarded by APSC chairman, who has no nexus or no interlink with this.
But you're not challenging the entire process of
No, and-
inquiry. Otherwise,
same thing, my lord. If the penalty goes, the entire thing goes, my lord. The charge sheet and the
penalty goes would mean that the inquiry proceeded as per procedure or
no,
no
that I have challenged. The procedural violations they have
the
committed.
conclusions could not have been the one that arrived at by the inquiry officer or by the disciplinary.
Those things are there, my lord, in the pleadings, my lord. Those things are there in the plea.
So let us,
Fine, my lord.
we'll keep it alive.
Fine, my lord.
We are
Fine.
not closing it.
No, secondly, lordship, so far as the urgency is concerned, lordship, this salary has not been stopped. One increment just. That your lordship will consider.
Why are you, urgency is there because you are stopping his increment.
Yes, lordship, that is the
Why-
decision. Now, if lordship comes to section 25, lordship, I mean rule 25 of discipline and appeal rules. Any decision by the appellate authority comes into effect with forthwith, lordship. So it has
Therefore,
already
the
been given effect.
Therefore, the urgency.
No,
You're
no,
questioning the urgency.
my friend is submitting as if his entire salary has been stopped.
No.
That is not there.
Penalty is increment.
He is
receiving his regular
urging-
salary.
He is urging
Except one
urgency
increment.
because you are stopping increment with a warning. According to him, nothing is.
Tomorrow if promotional prospect comes, this will come in my ACR.
Exactly. So there is an urgency. When can you file your affidavits?
Lordship will grant me 3 weeks time, lordship. I have not yet received instruction, lordship.
Instruction.
Heard counsel for the parties, Mr. P. Nayak, additional AG, renews his prayer for 3 weeks to complete instructions and file his affidavit. There are Mr. H.K. Das, Leonard, counsel for the petitioner submits that as per the last order passed by this court, the matter is fixed today for consideration of the interim prayer. Stop. Upon hearing the counsel for the parties at some length and upon perusal of the pleadings on the court, it is seen that the relief sought for in the present writ petition is for setting aside and quashing the order imposing penalty of withholding one increment and warning by order dated 12/9/2024. Stop. That apart, this court, by order dated 23/6/2025, while issuing notice, made it clear that any action taken in the matter during the pendency of the writ petition shall be subject to the further orders that may be passed in this case. Well, under such circumstances, this court is of the view that the prayers made by the petitioner can be reconsidered upon the affidavits filed by the petitioner as permitted. The court may consider passing appropriate interim orders if the affidavit by the department is not filed within the time prescribed. List on 27th August.
Fine.
1 day, so lordship on 28, lordship 27.
28th.
But 28 is Thursday, some difficulty, my lord. Maybe 27 or 29. 29, my lord.
29, lordship.
29 of
29th.
Yes, my lord.
29th of September.
Yes.
Sorry, August.
Sorry.
August.
Much obliged. Highly of.
Readings complete.
Yes, my lord.
Okay. What is your matter?
Oh, issue is, my lord, the writ petitioners, my lord, as well as the private respondent. They were, my lord, appointed in the same department and, my lord, under the same creation number, they were, my lord, appointed. And they were drawing similar salary, but, my lord, the grade pay is different for the private respondent just because he had a degree, my lord. Otherwise, my lord, they do the same functions on that is on record. The advertisement, my lord, at page 23 from the health department, my lord. Page 23, my lord, modular 4 and modular 1. So we are competing for modular 4, my lord. So, my lord, the essential qualification as appears in the advertisement, my lord, HSLC pass, diploma in preparation of medical embryology, models from a recognized medical institute, or experience of preparation of medical models from a medical college, or diploma or degree in fine arts from a government institution with 2 years experience in sculpture or preparation of models in plastic, POP or fiberglass, etc. Now, there is two posts, one is modular 4 and modular 1, but the essential qualification has been merged in a single column, we are for modular 4. So, as I gather knowledge from the records, this is essentially the requirement is SSLC pass along with diploma in preparation of model or embryology models from recognized medical institute. So anyway, so after competing, we got appointment, appointments order from 25 onwards, and private respondent number 6, he was also appointed. Page 27, Kindly see the creation number, 120 is the same for all these persons, petitioners as well as private respondent. So,
you have what? A diploma?
We are, in fact, petition number 1 is a graduate, and other two, they are HSLC pass, 10+2, along with certificates and or diploma, whatever it is called, from institutes in preparing models,
Which institute?
These are, institutes, it's given there. At paragraph 3, page 7 of the writ petition, writ petition number 1, he has completed this training under Chief Minister's Swaniyazan Yojana being sponsored by Directorate of Industries and Commerce, Government of Assam. Besides, he has also post-qualification experience in plastic injection molding. Then, the writ petition number 2, he did HSLC Arts, then passed having 3 years diploma from Jorhat Fine Arts Society, which is recognized by Lalit Kala Academy, New Delhi. Then, writ petition number 3, he is HSLC Arts and also have certificate of artist and modeler from Guwahati Paramedical Training Institute. And in any case, their appointments are not in dispute. So they are appointed, duly appointed, and as well as the private respondent, number 6. Now, the objective, of the qualification criteria for modular 4 is, essentially to have experience in preparation of models and all, models of different embryological models and all, that we have, that we have been doing. And one important thing, there's a DME opinion, Director of Medical Education's opinion, at page 41. He says, from a reply of an official query, page 41, we have come across this reply, It says, the work function of artist modeler and artist / projectionist are same
but photographer is different. Page 41.
Yes.
Then, my lord, number 2, it says the posts were created in different pay scale of the categories, perhaps either through oversight or not properly examining their duties and responsibilities at the time of creation. So essentially, my lord, he admits that the work function of these posts are same, my lord. Now, my lord, the important question, my lord, we have been given, my lord, the pay structure, my lord, well, when we were appointed, 3010 to 6075. And apart from that, my lord, there was a grade pay, my lord. And we have been given grade pay. We were given grade pay 2,400, my lord. And the graduate, my lord, candidates, they were given 3,000, my lord. And that was revised, my lord. After revision, my lord, we were getting 6,200 and they were getting 7,400 as a grade pay. So, my lord, my submission is that, my lord, despite doing similar functions of work, my lord, why the private respondent, because of having their graduate degree, my lord, will be given higher grade pay, my lord. And that goes to the
Graduate degree means you are also a graduate.
no. I'm read petitioner was a graduate, but that graduate is in different field, my lord. So they say, my lord, just because
The private respondents are graduates where
in fine arts.
Fine arts.
Yes, fine arts.
You are diploma holder.
I'm HSL. Yes, read petitioner one is a graduate, simple graduate, my lord, and along with other diplomas, my lord, and read petitioner 2 and 3 are HSLC plus other diploma. So, my lord, my submission is that, my lord, this, my lord, differentiation in issuing grade pay, my lord, it goes to the very edifice of the principle of equal pay and equal work, my lord. So that it goes against to that, my lord. So
what about qualifications?
That's what, my lord. Qualification, my lord, essential qualification from the advertisement itself. If we see, my lord, it's not spell out, my lord, whether only degree or fine arts, my lord, degree in fine arts will be given higher grade pay. It's not spell out here, my lord. The essential qualification, as I understand from the advertisement, my lord, HSLC pass. Kindly see, my lord, page 23.
Yes.
HSSLC pass, then, my lord, diploma in preparation of medical embryology.
What is the stand of the government here?
Yes, my lord, I'm coming to that, my lord. Now, my lord, kindly see their affidavit in opposition, my lord. At para, we had categorically stated, my lord, in our writ petition, at para 12, my lord, in our writ petition, my lord, regarding the DME's opinion, my lord, at para 12, and we have also annexed the particular reply of DME, my lord, annexure 9. So, my lord, the affidavit in opposition filed by the principal cum chief superintendent of Jorhat Medical College, my lord. Regarding that query, regarding that contention of ours, my lord, at para 12, it says, my lord, no comments, my lord. And may I read, my lord, their affidavit in opposition. At para 14 of their affidavit in opposition, my lord, that with regard to the statement made in para 12 of the writ petition, the deponent begs to offer no comments, but the deponent denies that there was.
What is the position in under the ROP?
Yes, my lord. So for ROP,
does the ROP lay down different scale of pay for?
Yes, my lord. As for ROP 2017, my lord, for modeler, but there is one, my lord, things to be understood, my lord. There is only the post of modeler. There is no modeler 4 and modeler 1. as per the advertisement, my lord, there is two posts, modular code and
When
modular.
was the advertisement?
It's only a modular.
Advertisement dated?
That is, my lord, dated 12/4/2010.
What is the ROP prior to 2000?
2010 ROP was existing, my lord.
What is 2010 ROP position?
According to 2010 ROP, my lord, there was a distinction regarding this degree and diploma.
And on that basis, the distinction has come.
Anyway, my lord, I will
Now
come to
you'll
that.
have to file your necessary applications, speak to the department to send it to the anomalies committee after 2017.
Yes, yes.
Has it been done?
No, madam. Probably, madam, now when the new minor pay commission will start, in that case probably, because anomaly committee once it is submitted,
2017.
no, once, madam, that time they will have to agitate, madam. They have not agitated, madam.
No, it was sent, my lord. It was sent.
But
As per
one
my
technical point, madam, so
instruction.
far as the madam notification which is under challenge before is honorable court at page 28A. This will come under the 309 rules of the madam ROP. It has been modified, madam. So probably it is a division bench, madam, we will have to look into it.
28?
Page 28A. For Lordship, you see the main notification, which is impugned here in page number 28. It is dated 19th of February 2011. This is the, my lord, by this notification, whatever resolutions the anomaly committee made, my lord, of the ROP 2010, that, my lord, has been accepted by the government in this particular notification. And Lordship will find it, my lord, at the last page, page number 33, para 9. Once accepted, it will become part of the 9. The notification number so and so dated 4th of February 2010 relating to resolution of the government on the recommendation of the Assam Pay Commission so and so, and the notification dated so and so relating to the pay schedule of the Assam Service revision of pay rules 2010 shall stand corrected accordingly. My lord, these rules are, my lord, 309 rules.
Including the schedule.
Yes, my lord, all will go there, my lord, because anomaly committee, whatever is given, my lord, it was accepted by the government. So it will be part of the ROP rules 2009. Now, if they are challenging this, my lord, then, my lord, it will be a challenge to the ROP rules itself of 2010.
Yes, ma'am.
No. But
yes.
Otherwise, only on not on merit, my lord, on the jurisdiction part I'm saying. In that case,
Are you challenging this notification?
Yes, that's the main prayer, my lord.
Then we'll have to refer it to the division bench.
Yes, ma'am. In that context, yes, that is correct. But may I point out one more thing, Lord?
Is it one of your prayer? Yes or no?
Yes, that is one of my prayers.
So if you're not abandoning that prayer, and in the context of this, if we have to look into it, then as per the rules, it must be before the division bench.
Yes, my lord. Keeping that aside for the time being, my lord, may I submit one thing, my lord? I have also filed one reply, affidavit reply against the appeal in opposition. What the present practice, my lord, what is going on regarding modular, my lord? Kindly see, my lord, they have modified, my lord, the rules, my lord. Now what they are doing, my lord, they used to, my lord, they used to provide, my lord, only one single grade pay, my lord. Kindly see page 68 of my affidavit reply, my lord. 68.
Yes.
So, my lord, kindly see modular at serial number 23, my lord. Now the qualification, my lord, has also come down, my lord. HSLC with training in modular from a government recognized institute. That's the only qualification. And the pay band, my lord, pay band 2 is given. And the grade pay is this only single grade pay, my lord, 6,200. It's the uniform grade pay, my lord. There is no discrimination regarding any education qualification, my lord. So, my lord, in that view of the matter, my lord, so my lord, prayer can also be considered, my lord. So what I am praying is that, my lord, only, my lord, uniform grade pay as is given to the my lord.
No, but are you challenging this or not?
That, yes, from the writ petition itself, we have made a challenge, my lord. We have made a challenge.
So you have made a challenge, but are you pursuing the challenge or not?
My lord, for giving a, my lord, complete justice, my lord, I can abandon that prayer, my lord, for the time being.
No, see, pursuant to the anomaly committee's report,
Yes.
these have been modified.
Yes.
Now, it has to be referred again to the anomaly committee pursuant to 2017 ROP.
Yes.
Has it been done or not?
Perhaps
Perhaps not done.
Perhaps not, otherwise, my lord, or my lord, might have been done, my lord, that's why, my lord, now they're getting the same, my lord, grade pay as per the
Now you're
annexure.
getting it.
No, we're not getting it. We're not getting it.
Then he has shown it, my lord, that is now, my lord, same,
Where?
that page 68, just now he has placed for modeler.
We're in the earlier grade pay only, my lord.
Yes, serial number 23, my
23,
lord,
yes.
page 68. Modeler, now qualification has also been mentioned,
Yes.
is so and so is 6,200. This one, this part I can clarify, my lord, what document he is now placing to clarify. That I can clarify. And decision advertisement.
This 6,200 is something, is the grade pay that you're,
No, we are not getting that grade.
you're
pay.
not getting.
We're not getting it. Our grade pay alert, as we have submitted our salary slips alert at page 43 of our read petition alert, annexure 11.
And what was the grade pay in the advertisement which you participated?
In the advertisement, nothing was mentioned. In the advertisement, nothing was mentioned. Otherwise,
Can you show us the anomaly committee report?
Lordship will see page 43.
Anomaly committee report.
I have it, my lord. Of 2017, I can place, plus I want to place, my lord, the months, my lord, page 43, Lordship will see. These are the pay slips of the petitioner with their claim, they are claiming. Lordship will see the months.
16.
It is 16 till February 2017. The ROP 2017 came into force in April 2017.
Yes.
So, my lord, this advertisement, probably if he has got the latest instruction, might be they are getting 6,200 as on date. If he's relying upon this document, my lord, it's too late, my lord. As on date, my lord, the grade pay is different from after the ROP 2017.
That instruction have not been given here.
No, sorry, come again, 43?
My lord, so far as this particular chart is concerned, this, my lord, only the months of, my lord, March 2016 to February 2017 has been given. The ROP 2017 came into force from April 2017.
Right.
So after that, probably, my lord, they are getting 6,200. Because, my lord, page 68, this is the advertisement of 2023, where the grade pay has been shown as 6,200. So by now, probably they are getting the revised, my lord, grade pay. So in that case, their grievance will be only for that period of the 10th ROP.
That I can take instruction. I may not been given the latest instructions regarding that.
Well, I get instructions.
Yes, sir.
But is the minutes, is the findings of the anomaly committee available here?
Well, so far as, my lord, ROP 2010 is concerned, I have got the, my lord, yes. 17, my lord, I can produce, my lord. Whether it was considered or not, if at all, my lord, some.
Produce it.
Yes.
Yeah, that is.
I got the minutes.
Third counsel for parties. Grievance of the petitioner is that although the petitioners and the private respondent are appointed and serving as modeler -4 pursuant to the selection and appointment by the respondent department. The respondent number 4 is getting the higher grade pay by virtue of the fact that he has attained a degree in fine arts as opposed to a diploma or a certificate obtained by the petitioners in fine arts. Stop. The petitioner submits that the nature of the job and the responsibilities are one and the same. Merely because the petitioners are diploma holders, they're not been considered for the grade pay, which the respondent number 4 is entitled to. Stop. It is also submitted by the counsel for the petitioner that pursuant to the report of the anomaly committee after ROP 2010, the pay structure stood revised, which has been put to challenge by the present petitioners. So the respondents are represented by Mr. B. Gogoi, Additional AG, State of Assam, who submits that if the amendment to the ROP 2010 is challenge, if the challenge to the amendment to the ROP 2010 is considered or continued by the petitioner, then the matter should be referred to the division bench, as it will amount to challenge to the ROP 2009 with ROP 2010, which is a 309 rules. Stop. The learned counsel for the petitioner, on the other hand, submits that at this stage he is not pressing that prayer. However, his only grievance is that while the respondent 4 is being granted a great pay, the petitioners are being deprived of the same, although they're all employed as modelers and the nature of their job and function is one and the same. Stop. In this context, this court is of the considered view that the report of the anomaly committee pertaining to the ROP 2017 would be necessary to look into, as it has been shown that with effect from 2017, you are receiving the great pay, no?
No, we are receiving the great pay, but lesser amount.
Lesser amounts. It will be necessary to peruse the findings of the anomaly committee pertaining to ROP 2017. Mr. Gogoi submits that he'll be able to produce the same within 2 weeks. List accordingly.
Well, this should be private respondent number 6, not 4.
Respondent 6.
Alright.
Mr. Bhattacharya appears for 6.
Can a date maybe fixed?
Bhattacharya appears for respondent number 6. 27th.
27th
August.
Alright.
May it please your lordship. In this matter, the petitioner who was working as a grade 4 employee in the National Institute of Open Schooling was disengaged or terminated from his service in 12/2022. So now what has happened, your lordship? Earlier there was a litigation, and in the earlier litigation, there was an order by the Honorable Court wherein he was directed to be considered for regularization. But subsequent thereafter, your lordship, without consideration of that, he's disengaged and terminated on the ground that there was a criminal case was filed, and in that case he was called for his statement, and there was an acquisition against him. But that case he was neither arrested nor convicted. Nothing has happened. It is continuing now. Now, under that circumstances, on the last, your lordship, order, your lordship will kindly see the order at page 13/6/2025 of this on report. The court directed the respondent authorities to bring on record what initiative has been taken with regard to the consideration of the petitioner's case for regularization, and that was directed to be placed before the court by an affidavit. Now they have filed an affidavit 2-3 days back, and in that affidavit they did not bring on record any such thing, just annexed a document wherein they said that this was also with regard the document which is annexed, that is of 2024, not of that period, and that was with regard to subsequent appointments and all. But no order, nothing, not a single whisper with regard to what consideration has been made as per this Honorable Court's direction. That is not. So that has been filed. Now the question is, does the disengagement or the termination was without any notice, nothing, just one line. There was a CBI case has been filed,
and therefore you are disengaged. But that goes against the order of this honorable court's order, which is that. So that order of this honorable court was on 29/11/2022 in, 24/5/2017 in WPC 1648. And that is reflected in the order dated of this honorable court's order dated 13/6/2025. This consideration, whether that was made on, if that consideration was not made, that this court also in the order had stated that they cannot be terminated without the consideration.
Where is that order?
That order, your lordship will find at page 29, annexure 9. It starts from 29. The direction, your lordship, operative direction, your lordship will see at page 34, the last paragraph. Page 34, the last paragraph. I'm not going into all the others. However, till consideration of this case of the petitioners by the respondents and NIOS in a manner as laid down by Umadevi Supra, services of the petitioner shall not be terminated. Further, they shall not be replaced by any other contractual or ad hoc. So there was a specific direction. And even then, thereafter, they have not done the whole. And they have just terminated me simply cite. It was not that there was any inquiry or something against me. In fact, nothing. There was the allegations or something was, there was no inquiry or notices has been given to me. Just because there is a case, in that case, I have been called by the CBI by a notice dated 8/2/2021, which is at page 65. And I appear, I have given my statement also. That is at page 63, type copy. And I have appeared, your lordship, and given my statement. And now, your lordship, termination without consideration, they could not do. There's a specific direction by the honorable court. Even if they wanted to terminate in regard to some other aspect, if it is a punitive part, then obviously they have to take a course of, your lordship, inquiry. But here in this case, I was not even arrested, neither convicted. So inquiry is a must. And secondly, first part has also not been done. Now they suppose that yes, it was supposed to be placed on the last occasion, your lordship. They have stated that they will place that on record, the consideration which was done. But that was by the affidavit that is filed, which I have seen, that is at page 80. Your lordship will kindly see there's nothing in the affidavit. The same thing was repeated again.
Page
80 is the additional affidavit filed by them to bring on record the consideration of the petitioner for regularization. This is filed by respondent 5 years. The second paragraph, they say the CBI inquiry in the matter is there, therefore he is disengaged as per the decision of the competent authority. Nothing further. Then the second paragraph, in view of the directions of the honorable court by the order dated so and so, it is respectfully submitted as per the prevailing norms and procedures, the engagement of daily wage staff through outsourcing is this nothing to do with me, your lords. This is subsequent that they have annexed that. That is the decision of 2024. Where is the decision of consideration as directed by a judicial order by this honorable? And they have on the last occasion submitted that they will place that.
Yes.
No, my lord, as per instruction, my lord, the order of the honorable court was considered because, my lord, they were engaged, the petitioner was engaged as outsourcing agencies, my lord. So that is that much they have. And the director has, my lord,
There was a direction by the court
lordship,
that their cases should be considered for regularization.
my lord.
Where was that consideration made?
Now, my lord, as they were engaged as outsources by the outsourcing agencies, my lord. The petitioner was engaged. This is the stand of the, my lord, respondent number 5, my lord.
Then you should have gone for a review of that order direction.
That's true, my lord. And apart from this, my lord, regarding disengagement, my lord, that is because of the criminal case, my lord, subsequent disengagement. And he was directed by the deputy director to disengage the petitioner. My
Who represents the deputy director?
deputy director, as per direction of assistant director, my lord, the petitioner was disengaged, my lord. 29 November 2022, my lord, page 83, my lord.
No, who issued that impugned letter?
My lord, impugned letter, that letter was issued by the assistant director, my lord.
And he was instructed by deputy director.
I was instructed by assistant director to disengage him, my lord. And thereafter, the private respondent number 5 disengaged him.
Respondent number 5, your lordship, passed the order. And all these are director, assistant director, regional director, all are parties in this scheme.
On what basis the direction instruction was issued?
Prima facie, it shows that, my lord, the order, earlier order passed by this honorable court, my lord, that has not been considered, this, my lord.
So what do you intend to do?
Well, I have talked to them, my lord. They are saying that they are stand as per paragraph 2 of my additional affidavit, my lord. That also.
So they don't want to comply with an order of the court. You did not file any contempt, Mr. Anand?
No, it was not filed because your lordship, the writ petition was subsequently, this was filed, your lordship. This order, your lordship,
24/5/2017, my lord, and subsequently 23 writ petition was filed.
You mean to say they were never considered? Direction is to consider.
My lord.
You were never considered.
Consider, my lord, as because they were engaged by outsourcing agencies, my lord.
We're asking you a
Lord.
clear question. Why don't you give us a clear answer?
Lord.
Why this order was allowed to stand? Why did you not file a review board? Why did you not point out before the court?
the court has indicated this, their point, that they were engaged initially, but even then this order was passed. That if your lordship reads that order from the beginning, it specifically indicates how they were appointed, where they have been appointed.
Who's the regional director here?
My lord, 5. I'm
5.
And
We have filed the affidavit.
where do the other directors stay? I mean, where are their offices? Director and assistant director?
Your lordship, the
Uttar Pradesh.
director is he's Gautam Buddhanagar. It means Greater
So
this
what is
Noida,
your
Noida.
prayer in the petition
Noida.
now? What do you want, Mr. Manna?
Prayer is basically in this case, prayer is basically, your lordship, cause the termination, that the termination of the disengagement, the dated so and so, so and so, and direct the respondent to reinstate the petitioner in the grade 4 post, and they will allow the petitioner to continue in his service.
Where is your affidavit again?
That affidavit, page 80.
Page
80.
80. Eight. 80 is something else.
Yes, 80 only.
It's a daily wages attendance sheet.
Oh, no, in my case, it's will shown as 80. Anyways.
Lordship, subsequent.
Martuk input. 80. 80.
This is the additional affidavit.
Yes. That is filed on the basis of the direction of this on report on 3/6/2025 with regard to the decision taken in the case of consideration of regularization of the petition. 74 to main problem was. And 13/6/25 what?
81 হ'ব লাগিছে।
Oh. Consideration part to decide.
নাই সেইটো নাই দিয়া।
নাই দিয়া।
পেৰাটো কি ক'লে?
The same thing, এইটোৱে ক'লো না, the language due to the approval of the competent authority.
All right. We will pass orders on Tuesday.
Lord.
List on Tuesday
Lord.
for orders.
Much of. May it please your lordships. While of this petitioner got retirement on 1/1/2014 lordships. And after his retirement lordships, an amount of rupees 1,58,760 was deducted on 19/8/2014 lordships.
He was employed as a
He was subordinate engineer lordships in APDCL lordships. Now lordships, he filed a writ petition in the year 2023 lordships. And regarding lordship delay, it is explained in paragraph number 6, 12 and 16 lordships. During his service period lordships since 2010 lordships, he as of now lordships, he was and is under medical treatment lordships. At present lordships, he requires helping hand for feeding and natural calls lordships. Now because of that, after the reduction, immediately he could not approach, but he went to medical treatment to various places, including lordships, Tamil Nadu lordships. Lordship, those documents, medical papers I have enclosed along with the writ petition. Now lordships, and also regarding delay part I have explained in paragraph 6, 12 and 16 lordships. Now lordships, as this amount is deducted lordships and it is illegally deducted for my retirement lordships, I have to get retirement benefits 7 lakhs. Out of 7 lakhs, this amount is deducted lordships. And lordships, as it is illegally deducted, I have approached before this honorable court to refund this amount with interest lordships. Lordship, similarly situated person has approached before this honorable court, and also lordship, this honorable court has given the direction to refund the money lordship. Lordship, those I have enclosed lordship.
page 52, Lordships. Page 52, Lordships. And another order, page 57. Lordships, in order dated 19/11/2015, Lordships, page 52, Lordships, in page 55, Lordships, there is opinion of Honorable Apex Court, Lordships. Here, Lordships, from the beginning, Lordship, page 55, after referring to the various case law on the subject starting from so and so, the Apex Court held that it may not be possible to postulate all possible situations of hardship which would govern employees on the issue of recovery, where payments have mistakenly made by the employer in excess of the entitlement of the employees. However, based on the various case laws, certain situations where recoveries by the employees would not be permissible in law have been called out. The Apex Court held as under. It is not possible to postulate all situations of hardships which would govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement, be that as it may based on the decision referred to herein above. We may, as a ready reference, summarize the following few situations where recoveries by the employers would be impossible in law. 1. Recovery from the employees belonging to Class 3 and Class 4 services, Group C and Group D service. Recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. Recovery from the employees where the excess payment have been made for a period in excess of 5 years before the order of recovery is issued. Recovery in case where an employee has wrongfully been required to discharge duties of a higher post and has been paid accordingly, even though he should have rightly been required to work against an inferior post. In any other case where the court arrives at the conclusion that recovery, if made from the employees, would be iniquitous or harsh or arbitrary to such an extent as would or outweigh the equitable balance of the employer's right to recover. In view of the law laid down by the Apex Court in Rafiq, Mercy and others, it is not necessary for this court to enter into a determination as to whether the salary drawn by the petitioner was in excess of their entitlement or not. This is so because even if we presume that the salary drawn by them was in excess of their entitlement, they would still stand protected from recovery by virtue of situation 2 and 3 as mentioned above. Lordships, and accordingly, Lordships, it is directed that in last Lordships, deduction made shall be refunded to the petitioner within 4 months from the date of receipt of a certified copy of this order. Lordships, similarly situated person has approached before His Honorable Court, Lordships, and accordingly, Lordships, this protection is given, Lordship. My humble prayer, this amount of 1,50,000, it is a very small amount for the APDCL, but it is a very big amount for me, lordships, because I have to take the medical treatment, lordships. As on now, lordships, I am bedridden, lordships.
Yes, Mr. Pathak, what do you say?
My lord, these judgments that my learned friend is referring to, these are not applicable to the present case.
Why?
Firstly, because the order of recovery was passed before the before the judgment was passed by the Honorable Supreme Court in the matter of Rafiq Mas. The recoveries after retirement, your lordship, only became bad, your lordship, after 18/12/2014. That is the date on which the judgment was passed by the Honorable Apex Court in the matter of Rafiq Mas. Before that, it was permissible, your lordship. That was the legal position. Now here, the cases which my learned friend was referring to, lordship will see the orders of recovery which
Was
were
it
passed.
excluded in the judgment?
Lordship?
The recoveries made earlier.
No, because if that, there are two aspects. Firstly, your lordship, if it is made retrospectively applicable, the law of retrospectivity says that unless it is made specifically applicable, it is always prospective. The law laid down by
It
the
is
Honorable.
always retrospective.
It will be retrospective because the order which is impugned, your lordship, was passed before the judgment passed by the Honorable Apex Court. The order was passed on 19/8/2014. And the judgment of the Apex Court in Rafiq Masi was passed on 18/12/2014.
What about these judgments that?
Yes, these judgments that my learned friend is referring to, lordship will see the impugned order at page number 53. The date of the order is there. The third paragraph, by order dated 19/3/2015. So this is after Rafiq Masi. This order was passed after Rafiq Masi.
In this case?
It is 19/8/2014. And this, in the second case, your lordship, the impugned order was passed on. In the second case, your lordship, the impugned order was passed on 26/2015. That your lordship will have at page number 58. Even that is after Rafiq Masi. And here the petitioner, he retired.
When was recovery was made in 2014?
2014.
Lordships. After my return.
So
the principle will have to be made applicable here.
Your lordship, the principle of, if this principle is made retrospectively applicable, your lordship, a Pandora's box will be open. Why I am worried, the petitioner's approach after 10 years, your lordship. That factor also has to be considered in the light of the constitutional bench judgment, which says that in essence, this is a claim for refund of money. So the bar under the Limitation Act applies to these kind of claims under Article 226.
3 years.
3 years. I have the judgment with me. If your lordship.
What do you say?
Lordship, regarding this lordship, I have explained in paragraph number 6, lordships. In 6, lordship, I have been in medical treatment since.
No, these are okay. You have heard what Mr. Pathak has argued. According to him, the Rafiq Masi judgment principle will be applicable prospectively. In your case, the recovery was made earlier. And there must have been other recoveries made in respect of other persons.
Lordships, after all recovery is done, it is admitted by them, and there is total violation of principles of natural justice.
No, this you are seeking interference of the recovery made on the principle called out by in Rafiq Masi, isn't it? Which is followed in the coordinate bench judgment. But in all these matters, these judgments, the recoveries were made after the judgment. In your case, it was made earlier. When the law, there was no law to say that recovery will be bad. So how do you say that the recovery which was made in 2014, at the time when it was made, is contrary to a law which has not been laid down at that point in time? Unless you can show us from Rafiq Masi that no, this judgment has to be read to be applicable retrospectively.
Lordships, another date may please be fixed, lordships.
Right.
Short date, lordships.
The petitioner is praying for setting aside the order by which excess payment received, excess drawal of salary and
Excess only deduction, Lordship, 1,50,000 from the retirement benefits.
reduction from the retirement benefit was made by the APDCL authority on the ground that excess payment was on the ground of excess drawal of pay.
Excess pay drawn and interest over.
Counsel for the petitioner has referred to the judgment rendered by coordinate bench in WPC number 6229 of 2015, where by order dated 19/11/2015, in respect of a similarly situated employee of the APDCL, the recovery made was interfered with and the amount was directed to be refunded. Stop. The judgment of the coordinate bench had relied on the law laid down by the apex court in Rafiq Mashi reported in so. Stop. Similar relief is sought for by the petitioner in the present proceedings. Counsel for the petitioner submits that as the petitioner was undergoing medical treatment, he was not in a position to immediately come and agitate the matter before the court, and therefore there was some delay. So Mr. Pathak, on the other end, objects to the prayer made by the petitioner. So he submits that the law laid down by the apex court in Rafiq Mashi will be applicable prospectively with effect from the date of the judgment, which is
December 18, 18 December 2014.
18/12/2014. So in the orders rendered by the coordinate benches in WPC 6229 of 2015 and other matters, the recoveries made in respect of those petitioners were after the judgment, after the date of delivery of judgment in Rafiq Mashi. Whereas in the case of the writ petitioner, the recovery was made on
19/8/2014.
19/8/2014, which is prior to the law laid down by the apex court in Rafiq Mashi. Stop. Mr. Pathak therefore submits that when the recovery was made, it cannot be held to be contrary to the law laid down by the apex court in Rafiq Mashi, as the judgment came to be rendered subsequently. Stop. The judgment has not been made applicable retrospectively, and consequently, the law laid down in the sale judgment in Rafiq Mashi will be applicable prospectively with effect from the date of the delivery of the judgment. Stop. Better part, the writ petitioner has approached this court almost 10 years pursuant to the order of recovery, and therefore the same is also barred in terms of the principle of law laid down in
State of Madhya Pradesh versus Bhailal Bhai.
There's another judgment very common. All right, State of Madhya Pradesh versus
Bhailal Bhai.
Bhailal Bhai reported in
1964, 6 SCR 261.
1964, 6 SCR
261.
61, which then the subsequent law laid down by the apex court in Tarsem Singh versus so and so, reported in so. In view of the submissions made by the respondents, the counsel for the petitioner seeks liberty of the court to address on these issues on some other date. He prays for
19th August.
19th August. No, right, 19th August.
Deeply.
He prays that the matter be listed after 2 weeks, based on 19th August.
Deeply.
That is 38 and 39. Today we have filed the affidavit reply, my lord.
Hmm?
Today we have filed the affidavit reply, my lord. And therefore this pleading shall be complete in both the cases, my lord. So my humble submission is that it may be fixed for a final disposal in the admission stage, my lord, in the month of first week of September, my lord.
I got the affidavit in reply today in the morning. So Lordship may take up this matter for admission hearing on a date suitable to your Lordship.
It is submitted by the counsel to the petitioner that the affidavit in reply has been filed today.
Yes.
During the course of the day, with copies being served on the respondent counsel. Consequently, the same is not available in the case report. Stop as agreed to by the counsel for the parties. Matter be listed on
September, my lord,
2nd of September.
2nd of September.
2nd of September for admission hearing. The registry will trace out the reply affidavit stated to be filed with the petitioner and connect it to the case report.
Right.
Mr. B. Purkashta for the petitioner, S. Chakraborty for the
ONGC.
ONGC.
Both the matters.
Mr. So-and-so on behalf of
SS Roy.
SS Roy and for respondent?
One.
One.
Article 40.
Yes.
Please, my lord. Matter pertains to family pension, my lord.
Family pension
Yes, ma'am.
between?
My lord, I am the legitimate wife, my lord.
To go for mediation. See if you can sort it out.
My lord.
My lord, we have already.
My lord.
Sort it out.
Yes, my lord.
You sort it out.
Yes, my lord.
What happened, my lord? Now, first wife died, my lord. Thereafter, second wife, after a few days left, my lord. Subsequently, petitioner was third wife, my lord.
Third wife.
Yes, my lord.
And you
My
are?
lord, they never married. The writ petitioner isn't married.
You are?
I am the second wife. I am the
Second.
married wife. Legitimate wife.
Legitimate.
Out
Legitimate
of
for
the
the second
time.
wife.
Petitioner being the third wife, my lord, out of their wedlock, my lord, two children born, my lord. They are now minor, my lord.
Now
Now,
you sort it out in the mediation. Go to mediation, sort it out.
May it please, my lord.
Hmm.
If for a moment, my lord would kindly have page, my lord, 57 for a moment, my lord. There is a communication from the department, my lord, the respondent authorities, 57, my lord.
Hmm.
Annexure 7 of my additional affidavit, my lord.
Yes.
My lord, this is from the DIGP CRPF to the Director Pay and Accounts Office, my lord. This is regarding the authorization of dependent family pension, my lord. May I read, my lord? It is submitted that number so and so X now late CTGD Juktiram Hira, that is our husband, my lord, of 49 BN CRPF, voluntarily retired on 1/2/2011, holding PPO number so and so.
Who's the petitioner here?
My lord,
Minu
petitioner
Hira.
is Minu Hira.
Hmm.
Third wife, my lord. But they didn't marry, my lord. That is not going to be counted because they are Hindus, my lord. That is under section 11, that is a void marriage, my lord.
Hmm.
Thereafter, my lord, family pension was not authorized by PAO along with retirement pension at the time due to non-availability of eligible family members. After death of the aforesaid pensioners, following dependent family members have applied for dependents family pension as per Rule 54 Sub Rule 7A 1 2B of the CCS Pension Rule 1972. Now, my lord, they have given this breakdown, my lord, of the eligible members, my lord. However, my lord, both of our names reflect at column number 2 and 3. 2 is me, my lord, Prabha Kumari Bora, and 3 is, my lord, my senior friend, Minu Hira. But, my lord, the first column, my lord, Sri Deepmani Hira, my lord, he is not eligible, my lord. By virtue of his age also, my lord, and also the fact that he is married. As per the CCS rules, my lord, only the son, my lord, who has not crossed 25 years of age and who is not married. He is married, my lord. It has come to our knowledge.
But petitioner is shown as the third wife.
Yes, my lord, but that will not be counted. As per section 11 of the Hindu Marriage Act, to my humble understanding, my lord, I was already his wife and he didn't divorce me. In fact, I was getting maintenance from him. Later on, he had lapsed also, but otherwise, I was his legally wedded wife. He didn't divorce me. He had abandoned me and got married to the writ petition.
You don't want to go for mediation?
My lord, if a direction may kindly be passed by this honorable court, that my lord, the said pension, family pension may be distributed between me, that is the legitimate wife, and children because of the illegitimate children of.
There has to be a finding first.
Yes, my lord, a committee may be constituted kindly.
No, no, not like that. We take it up on another day, 19th. 19 August.
My lord.
List on 19 August for admission reading. Readings are complete?
Pleadings are complete. Obliged, madam.
41.
Hey, please, your lordship. My senior is in legs of court number 14, my lord.
Yes.
Madam-
This is the fourth time they're defaulting in submitting the affidavit. Every day I'm coming, they're intentionally delaying submitting the affidavit and they're harassing me. So kindly take note of this. This is my PR only.
We pass over for time being, your lordship.
Have you filed the affidavit?
No, madam.
Then, do you want to file it?
That also I am not clear. My senior will submit, my lord.
Lordship can kindly see the previous two orders. On both the occasions, they had said that
Yes, we had.
We are
affidavits are
giving
ready there.
you, we'll give them further 2 weeks time to file their affidavit if they want to. We'll make it clear. Mr. D. Roy, petitioner in person, is present. MSS Mushari appears for the respondent. In terms of the liberty granted earlier, the affidavit required to be filed with the petitioner has not been filed. Stop. Further 2 weeks is granted to the respondent authorities to file their affidavit. Failure to file the affidavit within the time allotted may entail consequential orders from this court. List on 22nd August. Yes, 22nd August.
Obliged.
42.
Please, your lordship. Lordship, the petitioner's son was Assam Battalion lordship and he died on road accident lordship. And subsequently lordship, the left behind the daughter, wife, and one daughter and mother lordship. Mother is widow lordship. And there are some disputes arising lordship and regarding lordship police salary package compensation lordship. Now my little prayer is lordship, the mother is a 56 years old widow lady and his son was the serviceman. And so now lordship and some benefit is required for her survival lordship. The otherwise lordship,
Yes.
one, kindly
Lordship,
come
I
to
am
page number 19 lordship.
I am appearing for private respondent number 8.
Who are you?
I'm for the wife of the deceased.
And petitioner is?
This is mother
Mother.
lordship, widow mother lordship.
So under the pensionary benefits, it is the wife will get it, widow.
Wife lordship, yes, lordship, and there is the lordship, the and 2017 lordship
Pranam.
notification lordship, and the mother is also entitled lordship. But monthly,
Let us see.
lordship, monthly lordship, the salary is not required lordship, only compensation salary package lordship, some portion is required lordship, otherwise lordship, and she is dependent.
Yes, where?
Lordship, kindly.
This is for compassionate family pension.
Lordship, point 5.10 lordship, next page number 2. 5.10 lordship. May I read, sir?
So this is on a complaint. Have you lodged a complaint? Have you lodged a complaint?
Lordship, and already
You read 5.10.
Lordship, I have already made a representation, Lordship, and
Hmm.
that is why Lordship kindly come. Page number 19, Lordship. Page number 19. Representation already made, Lordship, and subsequently this order has passed by this, the Commandant of Office, Lordship, Assam Police Battalion. And Lordship, operating person, Lordship, the last para, Lordship. In this regard, I would like to submit here with a bank passbook, PAN card, Aadhaar card of Srimati Ranumai Tamali, mother of late so and so, and her prayer petition for getting part of compensation as her name in the mention and next of kin certificate, Lordship.
So
Lordship, but that is not his representation is not considered, Lordship, and that is already handed over to the bank authority, Lordship, and bank authority is not the authority to decide the pensionary benefit to the petitioner, Lordship, and other dependent, Lordship.
yes, I think what the Pranam Act or something is there.
Yes, Lordship.
Uh,
Lordship, as the PPO has already been Lordship sanctioned, and that's why the department has no role to play, Lordship.
so what about 5.10? You have the notification?
Lordship, as per Pranam, from gross salary 10% and up to, in exceptional case, 15%.
Has it been released?
No, Lordship, no.
Not released?
Right. Otherwise, Lordship, already they are in settled position, Lordship,
Settled position?
between the respondent number 8 and the
Lordship,
petitioner.
5.10. 5.10, it reads, Lordship, it is also provided that if the parents or other eligible family members are not looked after by the compassionate family pensioner, on receipt of such complaint from them, the competent authority will issue orders apportioning the compassionate family pension appropriately among the other eligible members. Lordship, this is the Accountant General Office, Lordship. They already have that means sanction and issued the orders, Lordship. So they are
This
the
is issued by Government of Assam.
no, Government of Assam. They are these things, but this apportioning and all these things, Lordship.
No, but there has to be an order by the administrative department. You'll have to take a call that, yes.
Okay, Lordship. Then we have to write.
Have you applied under the Pranam Act?
No, Lordship. But otherwise, Lordship, the representation was made, Lordship, that is page number 15.
Are you aware of the act available, Pranam Act?
No, Lordship.
You're not aware? Please have a look. Do you have a copy?
Yes, I have soft copy.
I'll give it to him.
Section 8.
You go through it, understand, and then explain to us. Next week.
Lordship, date maybe, Lordship.
No date, you first go through it, then explain to us. When you are ready, you make a mention, we'll list it.
Lordship, it will be time one day, Lordship. I'll get back ready, Lordship.
We had fixed the matter is fixed today. And you tell us that you don't know about the existence of a Pranam Act under which you are entitled. What is the purpose of fixing a matter for hearing it? We can't hear it unless you assist the court.
Exactly.
You can't assist unless you read what is applicable to you.
Can be, Lordship, 4, Lordship. I'll get ready. 4, Lordship. 4, okay.
4?
8.
4, 8.
Lordship.
All right, 4, 8. List on 4th.
Publish.
Please.
The petitioner, his father died as a process server mother on 7/11/12. Then his name was forwarded by the recommended for compassionate appointment by the committee, mother. That your lordship will get it at page 25. And on the basis of the recommendations, he was selected and by the committee consisting of the Chief Secretary, Commissioner Finance and Commissioner Revenue
That your lordship will get it at page 26. 26 may kindly be seen. The three members are state level committee, chief secretary, commissioner revenue and commissioner finance, and your lordship, his name, your lordship will get it as serial number 15, page 27.
Yes.
Then subsequently, he was appointed at page 29. He was appointed on 17/7/2017, and on the basis of his appointment, he got, and your lordship will kindly see the copy sent to the finance department. Copy has been marked serial number 2.
Yes.
Then he got salary for 3 months. Then thereafter, they did not get salaries. We filed a writ petition being 4358/2023, where the deputy commissioners, finance secretary, and the revenue mallet officials, they have filed their affidavit. But at page 71, because of this, we had to file the second writ petition, withdrawing the same earlier one, page 71.
Yes.
With reference to the above, I'm direct to say that the finance department has regretted its inability to concur to the proposal for ex post facto approval for filling up one vacant sanction post of grade 4 in respect of Neetu Make, who was appointed on compassionate ground under the amalgamated establishment of the Deputy Commissioner as so and so, is that the approval of the finance was not taken. That is the reason they say. So therefore, we had to withdraw and challenge this order. This is the impugn order now. And now they have filed their affidavit saying the same thing, that approval of the finance was not taken. Now, may I show your lordship the scheme of appointment as it existed on 1/6/2015. That your lordship will get it at
Are
page.
we going for a final disposal?
Yes, ma'am.
Then we'll take it up next week because we have to rise today.
Tuesday.
Tuesday on the 5th.
5th.
Listed for admission getting on Tuesday, on 5th. Hearing matters will.
Attempt for disposal is already
Attempt for
there.
disposal will be made on the next date fixed.
Release for admission item 49.
Yes.
My lord, matter relates to the promotion to the petitioner. On last occasion, my lord, they have to file punish instructions and file affidavit.
My lord, I am appearing on behalf of this 4, my lord. My lord, petitioner already, the petitioner, my lord, expired.
Petitioner expired.
Yes, ma'am. On 2/3/24.
We have not got any information. Maybe.
You take it and see.
Yes, sir.
It is submitted by the council appearing to the respondent that during pendency, the writ petitioner expired. Counsel for petitioner submits that he has no information. Matter stands deferred to be
My
listed
lord,
after
I'm
2
appearing
weeks,
from the Corporation Department.
enabling the petitioner counsel to ascertain the such information. Mr. So-and-so appears for Cooperation Department.
My lord, the extra copies in the last order, it was.
Petitioner has
Yes, not
expired.
Yes,
Let us see.
It has been given.
Before giving you extra copies is expired. After 2 weeks.
Bless.
50.
None appears for the petitioner, Mr. N. Upadhyay for the respondent. Passed over. Okay, so the day.
For hearing item 45.
Hearing matters will defer it. Hearing matters will
Well,
take it next week
My lord.
or any other date.
May I please your lordship? Lordship, item number 45. My senior is Lakin Court number 6. Okay, okay.
These items will take it up next week or a week after, and you take dates from the court master on a hearing day.
My lord.
All right.